We have breaking developments from the Washington Supreme Court that could send shockwaves through the entire pro-Second Amendment community. The Gators Guns case is in the spotlight, and what's unfolding here is far more than a simple legal dispute. It's a high-stakes battle over the scope and integrity of our fundamental right to keep and bear arms. Every gun owner in Washington, and frankly around the country, needs to pay attention because the court's ruling might become a playbook for other states looking to chip away at the Second Amendment. For those just tuning in, the Gators Guns case revolves around the constitutionality of Washington's ban on so-called high-capacity magazines and other firearm-related restrictions. The state is pushing an argument that only firearms in common use for self-defense truly deserve the protection of the Constitution, effectively trying to reduce a broad, foundational liberty into a narrow category. Meanwhile, Gators Guns, represented by the Silent Majority Foundation, says the state has no business selectively redefining which guns and accessories are protected enough. That fight is at the crux of this entire drama. What sets this case apart is the distinct possibility that a majority of the justices may be inclined to uphold the ban, despite well-established precedents that clarify how and why certain firearms or accessories fall under constitutional safeguards. The notion of public safety is being wielded like a sledgehammer to flatten the robust protections set out in Supreme Court cases such as District of Columbia v. Heller and New York State Rifle and Pistol Association v. Bruin. If Washington's highest court goes along with the state, that sledgehammer might smash more than just magazine rights. It could smash the logic behind common use protection altogether. Throughout the proceedings, there is tension between those who trust ordinary Americans to exercise their 2A rights responsibly and those who think government elites should micromanage every aspect of firearm ownership. The stakes couldn't be higher. When we talk about stakes, we're not just throwing around buzzwords. If the Washington Supreme Court decides the state can ban magazines above a certain capacity, or worse, can redefine the very meaning of in common use, it sets a dangerous precedent that could embolden other jurisdictions to impose their own draconian bans. There's a real possibility that firearm components we've taken for granted for decades will be outlawed, limited, or drowned in red tape. And here's the cold truth. Once a fundamental right is whittled down, it's rarely restored without a monumental legal fight. At the heart of this lawsuit is Gators Guns, a shop standing up not only for itself, but for the broader pro-Second Amendment community. Their legal team, backed by the Silent Majority Foundation, contends that an accessory such as a magazine is indispensable to the effective function of a firearm, making it an integral part of that right. According to their argument, common use cannot be hijacked to mean common use for self-defense alone. It should encompass all lawful purposes: recreation, collection, competition, and personal enjoyment, just as courts have repeatedly emphasized. If these justices somehow accept the state's narrower framework, it opens a Pandora's box of potential bans. On the other side is the Washington Attorney General's office, which has built its case around the premise that magazines aren't truly arms and that the state is justified in limiting them under its police powers to protect public safety. The state also leans on the narrative that these items are particularly dangerous, a phrase that differs meaningfully from dangerous and unusual. Why is that important? Because case law from the Supreme Court has clarified that truly dangerous and unusual weapons can sometimes be restricted. By morphing the phrase into particularly dangerous, the state attempts to sidestep the original meaning and treat ordinary items as if they were exotic instruments of destruction. Justice Cheryl Gordon McLeod appears to be the lone voice resistant to the state's spin, at least from what we've gathered. Her questioning shows skepticism that a large swath of firearms and accessories could be banished solely because the government insists on relabeling them. For those of us who believe the Second Amendment is not a second-class right, it's reassuring to see at least one justice pushing back. The oral arguments at the Washington Supreme Court played out like a dramatic spectacle, and we couldn't help but feel outraged by the lines of questioning. The state argued that so-called large-capacity magazines are neither arms nor essential for lawful purposes. Meanwhile, Gators Guns insisted that restricting ammunition capacity is effectively restricting the weapon itself. After all, a firearm without the means to feed ammo to the barrel is little more than a paperweight. Throughout the hearing, the phrase "common use for self-defense" popped up like a broken record. The state kept asserting that for an accessory to be constitutionally protected, It has to be used primarily for self-defense. Really? That's not how the Supreme Court has framed the Second Amendment. Heller and Bruen don't confine common use to any single lawful activity. Self-defense is a key part of it, sure, but so is sporting use, target shooting, hunting, or simply having a firearm for peace of mind in one's home. One especially jaw-dropping moment was when Justice Montoya Lewis questioned why these people live and need these things. The very fact that this line of questioning was entertained displays a fundamental misunderstanding. The Constitution doesn't demand that citizens prove need for any enumerated right. Imagine if we had to defend our need to speak freely or to practice our religion. Then there was Justice Gonzalez, who tangled himself up in the federal definition of a firearm. He seemed to entertain the idea that if magazines aren't defined as firearms under federal law, they might be devoid of constitutional protection. That approach completely overlooks the fact that courts have historically recognized ancillary rights, ammunition, components, and the ability to practice with one's firearm as integral to exercising the core right. In short, the state's stance twists legal precedent, conflates dangerous and unusual with particularly dangerous, and tries to diminish the scope of the Second Amendment. That's why this hearing came off as a do-or-die showdown for constitutional freedoms in Washington, with far-reaching implications no matter which side prevails. When you dissect the arguments presented, two things stand out: the state's unprecedented attempt to confine common use to a self-defense box, and Gators Guns' occasional missed opportunities to hammer home the broad application of the Second Amendment. The state's logic hinges on a narrative that a magazine is not an arm. Therefore, they claim it lacks constitutional protection. That line of thinking is just stupid. There's no other way to put it. A firearm without a functioning magazine might as well be a fancy club. There is also the matter of particularly dangerous being code for "we can ban whatever we feel like," a rhetorical trick that conveniently avoids the centuries-long tradition of labeling dangerous and unusual items as potential exceptions. It's worth noting that Gators Guns did a solid job reminding the justices of long-standing legal precedent on constitutional rights. They emphasized that courts, especially after Bruen, aren't supposed to engage in interest balancing that overrides enumerated freedoms. Yet, in the heat of the moment, there were times the defense could have tackled the state's claims more forcefully, especially when the justices latched onto the notion that a broader definition of common use might allow too many guns to be protected. The defense could have pointed directly to how Heller validated the ownership of handguns precisely because they are widely chosen by citizens for lawful purposes. Justice Cheryl Gordon MacLeod at least signaled interest in the more expansive reading of the Second Amendment, showing concern about the state's attempt to shoehorn self-defense as the sole reason for protection. Had the defense leveraged that momentum every time the state ventured into interest balancing or misguided definitions, it might have underscored just how much the Constitution disapproves of restricting an entire class of arms, especially those widely possessed by lawful owners. Still, the defense's key strength lies in tying the text and history of the Second Amendment to existing Supreme Court precedents, which clearly do not limit common-use firearms to self-defense alone. In the end, analyzing these arguments highlights the fundamental clash: an anti-gun state eager to expand its regulatory powers on firearms ownership versus patriots like us, people who are determined to preserve the full breadth of our fundamental rights. Sadly, pundits predict an 8-to-1 outcome in favor of the state, with Justice Cheryl Gordon MacLeod standing alone against the ban. That's a grim forecast for anyone who believes that enumerated rights shouldn't be watered down by bureaucratic or judicial whim. The majority of the Washington Supreme Court seems inclined to accept the narrative that government can wrap firearms and accessories in labels like particularly dangerous and bypass deeper constitutional analysis. Such a ruling would have consequences reaching far beyond this single case. Once a high court declares that restricting magazines, an accessory in widespread use, is fair game, politicians across the country will interpret it as a green light for additional bans. The slippery slope argument is often dismissed, but here it's a stark reality. If the courts redefine in common use or allow states to pick and choose what aspects of the Second Amendment they'll respect, we'll likely see a barrage of legislative initiatives aimed at other common firearms and components. Think about the possibilities if suddenly a new law branded semi-automatic rifles as particularly dangerous ignoring the millions of citizens who own them responsibly. This anticipated ruling also gives us an idea of how difficult it can be to fight state-level gun control measures in courts that appear sympathetic to government justifications. Legal challenges might need to reach the U.S. Supreme Court to stand a chance at overturning these expansions. And let's be honest, not every local gun shop or advocacy group has the resources for a Supreme Court showdown. The looming question is whether other states will rush to replicate Washington's approach, making it even more essential for national-level organizations to track these policies. A pro-state decision, especially if it's heavily one-sided, sends a discouraging signal to gun owners, fostering the impression that the Second Amendment can be carved away under the guise of public safety. Yet it also reminds us why it's important to stay vigilant about the composition of state courts. The justices we elect or who get appointed hold tremendous sway over how strictly rights are interpreted. Next, we have to ask, where does that leave the rest of us when these ground-shifting precedents are set? Stepping back from the intricacies of this single court battle, there's a wider issue looming over the entire pro-Second Amendment movement in Washington. The state has been steadily introducing new gun control measures that push the envelope further each time. Be it red flag laws, waiting periods, training mandates, or magazine limits, the trend is clear. Each measure by itself may look like a small encroachment, but collectively they create an environment where lawful gun owners are increasingly treated like suspects who need constant oversight. The Gators Guns case exemplifies this broader narrative. If the state manages to justify banning widely used magazines because they're allegedly too dangerous for everyday citizens, then what's next? Perhaps semi-automatic rifles will be targeted for having similar features to something the government deems off-limits. Or maybe entire categories of accessories, from triggers to stocks, will become fair game. Each victory for anti-gun forces lays the groundwork for even more expansive restrictions. That's why so many people are invested in this outcome. It's not just about how many rounds a magazine holds. It's about defending the constitutional framework that stops government overreach. But despite all this, there are concrete ways to resist. We can stay informed on legislative proposals, participate in public hearings, and demand transparency from politicians who seem bent on adopting every gun control fad that comes around. We can also support legal defense funds and advocacy organizations, which are often our last line of defense in court when lawmakers push beyond constitutional limits. Some folks might think it's enough to rely on major national organizations, but local efforts carry weight that can't be matched by out-of-state groups alone. Grassroots activism, consistent engagement with elected officials, and a strong coalition of gun owners can slow down or even stop some of the worst proposals from becoming law. Ultimately, the big picture here is that the Second Amendment won't defend itself. In an era where public safety rhetoric dominates headlines, it's on everyday citizens to remind officials that liberty matters too. If Gators Guns goes down in a lopsided defeat, we will see a flurry of copycat laws with each new wave pushing the boundary further. This could become the turning point that sparks renewed commitment among freedom-minded individuals in Washington and beyond. Before we wrap up, we want to thank you for sticking with me and staying informed on this critical issue. The next steps aren't complicated, but they require action, because if we stand by silently, the other side will exploit our complacency. Please share this video with your Pro2A friends to spread awareness. Also, please like, subscribe, and click on the little bell icon for more updates on the Gators Guns case. Thanks again for watching, and we'll see you in the next one.